you're supposed to do, then we can't do what we need to do. And then it becomes a mess. And we just don't like that. To that end, how do we prepare clients for court?
So it's very, very important to have goals in mind. What the client needs to be clear on what they are trying to accomplish. And then on our end, it is our job to tell the client what is reasonable, what is not reasonable, what's going to fly in court, what's absolutely not going to fly in court. Yes, you can testify as to this. No, you are not testifying as to that. This is a no-fault state. So it doesn't matter what the former spouse or father, mother of your child did or said. Whatever you feel about them, it really doesn't matter. And as long as they're not a risk of harm to their child or your children, then they're getting their time. You're not getting sole custody. So I really have that serious talk with the client about what the expectations are. And then with my familiarity with the bench officers, I let them know what bench officers that they're in front of, what the preference is, what they absolutely dislike. And usually that definitely tones down the client. And that's what I love about this firm is that we tone down the cases. We're not emotional. We're not blowing up our client to have unreasonable expectations. And so we go in and we represent to the court as the reasonable party. And so I always tell clients that be the reasonable party, understand that this is likely going to happen, and you have to work around that.
And reasonable doesn't mean you're going to be a doormat. It means just you have to know how to present your side in a way that the court is going to respect. If you go in and you're yelling and you're screaming and you're rolling your eyes, this is not TV. And I know we've had some instances over the last couple months that people kind of advocate that. That's just not reality. So please don't go to court in that manner. Mm-hmm. What is one thing you all wish clients would know before they contact a law firm?
Can I make one comment about court?
Sure.
Even before you get into the courtroom, I like to have a conversation with my clients for their first time going into court or into a conference. How you present yourself is important. Mm-hmm. You need to make sure your background is clear. It's not a lot of sounds in the background. You're dressed appropriately. If you have your spouse involved, your spouse is not making faces or, snickering.
Or whispering in the background. We can hear that.
Yeah. You really want to be mindful of how you're presenting yourself to the judge and to opposing counsel. Everyone is taking notes on that, and you can definitely get a feel of a vibe through, Zoom. So be mindful. Be very mindful of your background surroundings and the people that you have. If your spouse is an issue in the case, maybe leave your spouse off the Zoom.
Please.
Yes.
Please.
Yes.
Thank you. And turn off your mic and your video, right? Because it is open court. Mm-hmm. So whatever you're doing, if you're farting, burping, whatever, I say that because it has happened. And just be very, very mindful of that. And so right now we are doing both. We're going in person and remote, but a lot of our hearings are still remote. So what Candace has alluded to is very, very important. So I was asking, what is one thing that you wish clients knew or that they did or that they understood before they come to see us?
Oh, I have to chime in back on the honesty and integrity. Clients must tell us really everything as much as possible. Clients have to remember that whomever they're divorcing or they were intimate with that created a child, they were very vulnerable to at one point and talked about everything. So if you're not telling us,
They're going to tell
They're
them.
telling their attorney or the judge, and then I cannot stand when I'm speaking to opposing counsel and opposing counsel is telling me about my client and information that my client should say. So I don't understand why clients feel I'm not going to tell my attorney this and it's not going to come out. It's going to come out. It'll come out in subpoenas. It'll come out in I know this, I know that. Your spouse or former spouse knows you very well, knows your accounts, knows what you've been hiding. You need to say something to us so we can prepare for it. Otherwise, it's coming out another way, and that really makes this difficult. It can damage the legal relationship, really, because
and your credibility in the court.
The credibility, yes, yeah. And a client has a duty to be honest to us, so that's already a breach of the contract right there. So if a client can't be honest with their attorney, then they're truly not trying, in my opinion, not trying to come to a resolution. They just want to fight.
And that's a problem for us.
Yes.
I wish people would know how much they need to interact with the firm and with their case, because I feel as though many people may think that they can just kind of be lackadaisical about it, and it's a serious case. You have to go to court. We have to submit documents by a certain time, so it's a very serious process to go through, and it should be taken seriously and not just kind of thrown to the side and forgotten about.
I think there's two things that I think people should be mindful of when they're hiring counsel. One is when you've come to the Graves Law Firm, you've gotten the best. So trust us. We know what we're doing. Attorney Graves is phenomenal. She's literally the bar. So when you come to the Graves Law Firm, you're getting top-notch representation. There's some respect that goes along with that. And then secondly, we all have Google. We can Google some things along the way, but Google does not make you an expert. So also be mindful. You're Googling for information, not because you're telling Attorney Graves or us how to do our job. There's a mutual respect where we understand your situation and what you have going on, and you also are able to understand that we have a job to do and we know how to do our job and we will not fail. So I think those are the things that clients need to be mindful of or they should consider.
Izzy?
I think the two things I would touch on that everyone's probably touched on since we've been here is probably communication and a time frame. Because although I am the legal assistant, so I don't handle much work like everyone else does, it's still being able to reach out to a client when it comes to Attorney Graves asking me a question about their case that only the client would know, or Candace or Kyla coming asking me about something. I have no idea what's going on per se, so I have to reach out to a client when it comes to getting information from them, and they go radio silent. No one wants to come back to their boss empty-handed. No one wants to do that, especially me. So it's a little difficult when clients want to be radio silent, or when you call them and they don't want to pick up the phone, but then they'll call you at like 6 p.m. What the heck?
Knowing you're off,
No,
the doors are closed.
It close at 4 p.m. Why are you calling me at 6 p.m. when I try to call you at a good 11 a.m.? You should be awake. You should be doing your things. But I would say just being able to communicate and respond, like come prepared if you're seeking legal assistance. Come prepared, know what to expect. Like you're going to be getting emails from your attorneys, your paralegals, asking you questions about your case. We would like answers.
I wanted you all to see this so you can see that it's a complicated process. And if you're calling to speak to me, so we're going to talk about expectations, right? So I am managing everybody. And that means like all of your cases, they're being managed by my staff, but then I manage everything. So it's important to understand the boundaries that I have in place. Yes, you have to schedule time to talk to me. I'm just not available at any point of the day to pick up the phone and say, hey, and chit chat with you for 30 minutes, and I have a calendar full of appointments. So I want to give each client what they need. So that means booking time to speak to me. And then being mindful that I'm a person and a mother first. So when you're blowing me up on Saturday and I'm at my son's basketball game, there's not much I'm going to do because unfortunately I'm just not going to leave his game to take the call unless it's like an emergency. But typically if it's the weekend and it's an emergency, there's not much that I can do. So it's being respectful of your attorney's time. And especially as Candace said, we work really hard to be really good and to set the bar high and to give you the services that you want. So in return, you have to respect the boundaries of after hours, weekends. That's important to me. What boundaries are important to you all?
Like, I'm going to adjust Candace's mic.
Okay. I thought you were going to give us your boundary.
Oh, yeah.
I was like, my mic seems to be getting lower.
Candace is going like this.
That's a better hat for us. Mm-hmm. Let me scoot up. I keep slipping down so my feet will touch the floor.
They are. You need a little book.
A book.
Yeah.
The yellow pages.
Okay, and then this one.
Okay, what's the question again?
Boundaries.
What are your boundaries?
Girl, I'm texting with clients all through the night. I do not care. I don't care.
Not me.
So I'm going to re-ask the question. So what are some boundaries you wish clients knew about or should know about when they start this process?
So I understand that clients could really care less that we're human, but they should know that we are human. This is our jobs, our careers. But yes, we have other tasks in our daily lives. And my belief truly is that we aren't emergency responders. If you have an emergency, if your child is harmed or you need some sort of restraining order, there's emergency protective orders, criminal protective orders that can be issued by calling the police and calling actual emergency responders. So I do appreciate those boundaries, or I would think that clients would understand that, one, we are human, and two, we are not emergency responders. There are legal actions and steps we can take in sub-emergency situations that can be dealt with during business hours. And there are other resources available for true emergencies.
I think I don't really respect my own boundaries, so I don't really enforce that.
Others.
Yeah, so I don't really enforce that on the client because I don't mind, if you call me on the weekend or text, I don't really mind that. But in order to respect Attorney Gray's boundaries, I always request before a client requests a call with her to maybe send an email first and then allow her to determine if that warrants a call, or could the questions or comments or concerns be addressed in an email, which is so much easier and quicker for her to get to. Her schedule backs up very quickly, and it will put your matter off to maybe the next week. So sending an email, getting ahead of the issue and allowing her time to digest and take it in, I think helps manage her boundaries. So I think, keeping that in mind, some things are email. I know when you're at work, you're like, that meeting could have been an email. The same here. So, yeah.
I agree. I think many times calls can be emails. And I think another boundary is kind of piggybacking off of earlier, being a therapist, because it's sometimes when you're trying to get very specific information and you're not getting specific answers, you're getting narratives that can be difficult to put that into like legalese and court, what the court will accept. And so I think it's really important for clients to really think about what they want to say and what they want to ask before they speak with a paralegal or Attorney Graves or Attorney Shovak, and really get it together so that they can confidently ask you what they want. Otherwise, it's very hard to get information, very specific information.
And I mean, to that end, Izzy, did you have something to say?
I mean, nobody's really crossed my boundaries yet.
Do you have boundaries?
Yeah, I'm scared. Y'all gotta be careful. It's just a simple phone call. Like, no one really realizes how busy you can be. So it's that constant phone call I get asking, can I speak to Attorney Graves right now? No, you cannot. No, you can. I'm looking at our calendar. I can't even speak with Attorney Graves right now. Like,
Right.
It's gonna take a while.
Right.
Serious.
Yeah.
You can't call the
Right.
CEO of Amazon. So,
Right.
I mean, hello. The CEO is busy.
Right. And you set appointments. And I think to that end, we are going to talk to you. We do have a standard that typically someone is going to reach back out to you within 24 hours. So it's not that we're never going to talk to you. We're going to take your information and hide from you. But it's important to respect the process, right? Because it is a process. So to that end, let's speak to, is it done within a month of filing? Like how long do you think the process takes, and kind of how do you manage that desire to be done within a month of filing?
Oh, well, what's the classic answer? It depends.
It depends. Yeah.
So, are the parties reasonable? And if there is opposing counsel, is opposing counsel reasonable? Or are they emotionally involved? Because that can also lengthen the process, which is a pet peeve of mine in family law. Are emotionally involved opposing counsels, because it is our job to be the reasonable person, calm the clients down, keep them focused on their goals. Let's get to the resolution. So nothing is happening. Well, I don't want to say nothing is happening with 6 months, because if it's two people that are like, let's get this done, let's come to an agreement. I understand we have to share custody. I understand that we have to divide assets. It can be done within some months. But then if there's people that just want to fight and bicker over every little thing, and then that can be 1-2 years. It can go into the years. Mm-hmm. So it just depends on what are the client's goals, what are their true intentions. Do they truly want to separate from this person, have peace, have a life, or do they just want to keep trying to get back at the other person, or even emotionally harm, their children with this separation? And unfortunately, there are people that practice that.
Agreed. Anyone else?
I think I would touch on that. My last task was calling outstanding balances at the firm, and the consequence is, when is this going to be done? I can't afford this. I have learned that the length of your case depends on how much you can put your pride away. There's a lot of people who are, I want this, I want that, I deserve this, they deserve nothing. You're spending money because you don't want to put your pride away, and be reasonable and negotiate with the other party. If you don't want to pay this much, I would say be able to negotiate and be open to negotiate and be reasonable. Sometimes you're not going to get everything you want out of this, but it's also being able to realize I just have to suck it up and get over with it if I don't want to pay all this money for it.
I would just add to that also that the court has their own process, and they go through things at their own rate and speed. So sometimes if we've already submitted a document, filed a document, and we're getting constant calls and emails from clients like, is it done yet? Is it filed? Or is the judge approve it? And it can take a month to 2 months for a judge to approve what we filed. So it's also kind of dependent on the court as well. And I think that's something that clients really, really should keep in mind.
Nothing. I think this is so helpful, because I think people really need to know what happens behind the scenes, right? A lot of times people just see me, and I wanted people to know I actually work on the times that I'm not recording and trying to provide as much information for those of you looking into this process. It is a lot of work. As you see, there's a lot of people handling what needs to be done. I really care about my craft. Everyone here cares about the craft, and it's very important that you find someone that cares. To that end, what is one tip, one thing you would like to leave with those embarking on this process, thinking about it?
Be transparent. Be open. Know that we are here to support you, and we have your best interest at heart.
I would say be prepared for whatever happens.
would say please be interactive and involved as much as you can.
My ongoing theme has been have your goals and intentions in mind, but also take care of yourself. So take those steps to get therapy, whatever it is, because clients are transitioning from a life with someone and kids and all of that to being a single parent, things like that. It can be a lot emotionally and mentally, especially with court involved. So definitely take those steps to take care of yourself.
And to piggyback on what Brianna's saying, for the clients that can't afford to get a divorce and seek therapy, I say grab a journal and write it down. Then you can revisit it in a year or after your divorce to see how you were feeling, because it's important to acknowledge how you feel. Even though we can't take it all on, that journal could take everything on. It's really important to get how you feel out and onto paper. So I always suggest, if I hear a client say, hey, I can't afford both, or I can no longer afford to go to therapy, a journal works. I journal, maybe some of these ladies journal, and it definitely helps.
I agree. Well, I am so happy that you all got to meet my wonderful staff. What I do does not get done without them. I guess my lasting tip is it is a process. You're going to have to take it step by step and let us do our thing, and you will make it to the other side. So we hope you enjoyed us, and thank you so much for tuning in to Legally Uncensored.